It's Wednesday, so that tonight means it is all about the law. The showdown over Supreme Court nominee Neil Gorsuch coming to a head and both sides digging in. We'll take a look at how we got to this point and how Gorsuch could impact the court if and when he's voted in. Then Fox paying out millions and millions of bucks to women alleging abuse by this guy, star anchor Bill O'Reilly. The network's strategy has been to settle up and pay up. Question is, could that backfire in the long run? Also, dozens of people, they watched the sexual assault unfold live on Facebook. Two guys accused of raping the girl, they're under arrest. But could people who watched and didn't do anything, including notify authorities, also be in trouble with the law? Good evening, everyone, and welcome to RFL. I'm Richard French. Thank you so much for joining us this Wednesday evening. We do start, though, with some news out of Washington where it is never dull. Steve Bannon, the White House chief strategist, he has been booted from his position on the National Security Council. Bannon's appointment to the council, it was controversial that civilians are traditionally kept away from a permanent position in the NSC. Replacing Bannon will be the National Intelligence Director, Dan Coats, and the chairman of the Joint Chiefs of Staff, Marine Colonel General Joseph Dunford. Both, they previously had their positions on the council downgraded when Bannon was elevated to the post. And joining me now, senior political correspondent Andrew Whitman. And Andrew, what are we hearing precipitated this?
Well, we're actually hearing that the move on Bannon came up at the behest of National Security Advisor H.R. McMaster. And back-channel reporting out of the White House is saying McMaster was so unhappy with Bannon on the NSC, he was willing to resign if Trump did not remove Bannon from the National Security Council. Now, we're hearing two threads of reaction from the White House. The first saying that, look, Bannon was only on the National Security Council to basically monitor Mike Flynn. And now that Mike Flynn is gone, there's no need for Bannon on that council, though that innuendo may be coming from Steve Bannon or Bannon supporters in the White House. The other is that Trump was unhappy with Bannon, saying that he was too aggressive in seeking the spotlight, either directly or indirectly in the press. That getting reported this afternoon by Fox, and word of that may have leaked from a different portion of the White House. There's also a little bit of a power struggle in play. Jared Kushner, the president's son-in-law, his star has been on the rise within the Trump universe inside the White House. It may not be a coincidence that Kushner is getting plum assignments at the same time that Bannon is being somewhat demoted off of the National Security Council, Rich.
It almost sounds like an episode of Game of Thrones here. And just to add one more, we're also hearing there's frustrations within both State Department and also over at the UN, where again, as the profile, the portfolio of Jared Kushner grows here, he's meeting with world leaders before even the Secretary of State and others are. And apparently that's causing a lot of consternation and frustration in a lot of chapters. All right. Next, obviously, Andrew, we're going to move on to the nomination of Neil Gorsuch to the Supreme Court. Certainly the issue this week. Senate Republicans, they've scheduled a final vote on Friday and a procedural vote known as cloture tomorrow. Cloture vote is the 60-vote threshold that Gorsuch's nomination will not reach. That is, Democrats have already gone on record that more than 40 of them will oppose his confirmation. This would lead to the filibuster. Republicans expected to break that filibuster by changing the rules of the Senate in a move referred to as the nuclear option. But as the Senate prepares to go nuclear, we wanted to trace how we got to this point. And it has not happened in just the last 70 some odd days. When did the Supreme Court nominations become so polarized and politicized? And how has that changed, as we said, over the years? Andrew, he's been looking at the history of the modern confirmation fights, and it's interesting. You can point, right, Andrew, to a couple key points in history.
You can actually, Rich, although the look that we're going to do tonight actually starts a little bit earlier than most people might expect. Look, each Supreme Court nominee story is a different one, so the Senate does consider specific factors for each nomination. But there are trends that inform where we are and how we got there. And as our nation's and the Senate's politics have changed, so have the paths and hurdles facing those seeking elevation to our nation's highest court. When most people think of modern Supreme Court confirmation fights, they think controversy first in names like Robert Bork and Clarence Thomas. But the partisan trends we see today may well have begun in 1968 with the retirement of Chief Justice Earl Warren. President Lyndon Johnson, in his final year of office, nominated Justice Abe Fortas to replace Warren as chief. But Fortas was seen as too liberal by conservatives, and in an era where both parties still had liberal and conservative members, a bipartisan group threatened to block SCOTUS, whose nomination was withdrawn, allowing the newly elected president, Richard Nixon, to replace Warren. Nixon's first two choices for the bench, Clement Haynsworth and Harold Carswell, were both rejected by bipartisan majorities in the Senate, both primarily for their records on civil rights. That seat eventually went to Justice Harry Blackmun. But the Senate rejections of Haynsworth and Carswell remain unusual. Since 1968, 24 people have been formally nominated to the court. 16 have been confirmed, 3 have been rejected in a Senate vote, 4 have withdrawn their nominations after Senate rejection seemed likely, and 1 had no action taken on his nomination. None have been filibustered. As for the last 16 who have made it to the court since 1969, 12 have been appointed by Republican presidents and just 4 by Democrats. And even in this more partisan era, certain traits have all but ensured bipartisan confirmations. Nominees seen as having moderate views and who have avoided personal scandal have gotten bipartisan support. Nominees seen as being particularly liberal or conservative have met with more opposition, as have nominees with questionable finances, those appearing to lack the requisite competency for the court, or in one case, a nominee who smoked marijuana as an adult. It was political ideology that undid the nomination of Robert Bork, named by President Reagan in 1987. Bork was seen as extremely conservative, particularly on civil rights. He was rejected in a bipartisan vote, after which Reagan nominated Douglas Ginsburg, who had been named a federal appeals court judge just 1 year prior. Ginsburg's nomination was withdrawn after reports he used marijuana as a professor in the early 1970s. To many, the Bork hearings changed the nature of the confirmation process, namely that a nominee could be rejected for ideological reasons. But if Bork soiled the confirmation process, his nomination did not soil confirmation voting. Of the next 5 nominees, Kennedy, Souter, Thomas, Ginsburg, and Breyer, all were confirmed and all by wide majorities, except for Clarence Thomas, who was confirmed despite allegations of sexual harassment, claims conservatives believe were exaggerated to mask objections to Thomas's conservative ideology. But the event that may have changed both the court and the confirmation process more than any other came in late 2000, Bush versus Gore. The court ruled 5-4 for Bush entirely along party and ideological lines. Many Democrats still feel like the court elected Bush. Since then, 6 people have been nominated for the court, 4 have been confirmed, but none have been confirmed with more than 78% of all Senate votes, far more partisan than the historical averages. And one could argue those 4 justices, Roberts, Alito, Sotomayor, and Kagan, have been less moderate than the court's previous norms. Nominee number 5 since Bush v. Gore, Merrick Garland, whose nomination was ignored by the Senate. Nominee number 6 is Neil Gorsuch.
Let's bring in our legal panel right now to talk about all things Gorsuch. Jim Kasouras, criminal defense attorney in Manhattan, sits on the board of directors of the New York City Criminal Bar Association, frequently lecturing at New York Law and the bar associations of both Queens and New York City. Doug Von Oist, founding partner of Carsten Von Oist, focusing on corporate misconduct and selected by the Legal 500 as one of the most influential trial lawyers in the nation. And Mayo Bartlett joins us, an attorney at the law offices of Mayo Bartlett PLLC and a former chief of the Bias Crimes Unit at the Westchester County DA's office. All right, guys, let's dig into this one. I can tell everyone how the story's going to end. He's not going to get 60 votes. There's more than 40 some odd Democrats who are already on record to say they're going to oppose it. Then they're going to do the nuclear option, and then Friday, Neil Gorsuch, he's going to be the 9th Supreme Court justice. But how we got here and where we are to this point, I understand both arguments. And if you take the Merrick Garland thing out of the way, which is you guys didn't even give my guy a hearing, let alone a vote here, we haven't forgotten it, you're going to pay the price this time around. But nonetheless, I always thought if the guy or the woman has the right qualifications, that's the determination. Now, whether a Republican president wants a conservative guy, a Democratic president wants a progressive person, as long as they were qualified. Now it's looked through the prism, Jimmy, of, well, what are they going to do with Roe v. Wade? What are they going to do? How do they feel about Citizens United? Or where are we going to go on this? I appreciate both sides, but what's the right way to do it if they want to represent the best interests of America?
The right way to do it is to take somebody who is eminently qualified, and it is up to the president nominating that person to find somebody who not only is eminently qualified, but is not so to one side that it's going to cause these problems. You know, Rich, what I think has changed is not so much the process, but the politics. Because what has happened in the last few years is that everything just goes along party lines. If the Republicans say yes, the Democrats say no, and it's almost without any thinking or logic or anything like that. The bottom line is Merrick Garland was ignored. It's true, it wasn't right. To be honest with you, I don't know in this day and age that the Democrats wouldn't have done the same thing if the roles were reversed. Be that as it may, it's done. Now we have somebody who's highly qualified and is not even being evaluated in the right way, in my opinion.
Well, to that end, the other argument, if you separate the politics, is in the confirmation hearings, Doug, Merrick Garland did what many have done before him and avoided answering every single question. And he used the logic. Right, Gorsuch, excuse me, the Ginsburg thing, which is, hey, if I say anything here, it could prejudge or color what I would do if confirmed and I'm on the court. We didn't learn anything about him other than the guy's pretty good on his feet. There's been some questionable cases. I'm sure we'll talk about him in a second. But nonetheless, he's got a good resume, good head of hair, and he knows how to not answer a question. Of course politics is going to be involved. It's Washington. And it's also a lifetime appointment. If the politics are getting in the way, what's the right way to learn about somebody that could be on the court for 40 years?
Right. I think the process is broken now. The process should take place where the person is asked candid questions and gives candid answers. The whole reason for the process, you're not supposed to prejudge cases, and we all understand that. You're not supposed to give a whole bunch of facts and say what you were supposed to do. But those senators do have a right to know what's in this man's head before they confirm him. They have a right to ask him questions. Now you're having the opposite, where people are being put up for these positions that have not written opinions in the past, so you're actually encouraging.
Consciously not written
right,
opinions,
and that's the problem. So when somebody says, well, you shouldn't ask him questions because he's not supposed to prejudge cases, he's not prejudging cases. He's allowed to give his opinion about the weaknesses or the strengths of cases that exist. So the process is broken.
In terms of the stakes, Mayo, I think everybody agrees. There's got to be a better way to do this than the way we're doing it right now. It's such a hyper-partisan. But I also have looked at some of the recent numbers, and I think people forget, Clarence Thomas, there was baggage that was involved there. I understand why people were conflicted about voting. But nonetheless, recent confirmations have been overwhelming. Should the issues before the court in any way mitigate what you want out of the justice going on? For example, right now there's questions about where does the rights of corporations start and stop and employee treatment. If you look at Gorsuch's record from his time as a federal judge in Denver, every single time he favored for the corporation. And we're talking about things like Hobby Lobby and all the rest here. It matters, Citizens United whatsoever. If we feel he's out of the mainstream, should that be enough for a senator, to say no? Or should they say, wait a minute, this has been a jurist that has not in any way disqualified himself in his or her experience on the bench. She's got all the proper credentials to do the job. He's learned, and moreover, his record reflects here proper jurisprudence. Sure. How do you look at it in the prism of the real world versus, whether or not the resume is good enough?
I think you need to determine whether you have someone who is going to be fair and impartial. And that means you don't come in with any preconceived notion of what should happen. If you have anyone too far either side, that person probably can't do the job very well. You want to look at people who are going to try to interpret the Constitution. You understand that there are going to be people who have different interpretations of the Constitution throughout history, different judges. You've had judges who have reversed themselves essentially in their interpretation of the Constitution, but it shouldn't be to get us to a desired result. So at the end of the day, it shouldn't be that, I believe corporations are equal people to you and I want to allow them to determine what kind of medicine you can have, things along those lines. As long as you can do that, then you're going to understand that from time to time you're going to have rulings that are unpopular, but that's not really the issue. The issue is, as Jim said, you want to get the most qualified people. And look, I sit on a judicial screening committee. To be a judge in Westchester County, or if you come through our Westchester County Bar Association's judicial screening and you are a judge running for Supreme Court in the 9th Judicial District, you have to answer certain questions. If you don't come before us, we'll find you not qualified by failure to appear. You have to answer the questions. Today, candidates across the board, whether you're talking about presidential or anything else, have made an art form of not answering the questions.
So you think to be a justice in Westchester, you actually have to be more transparent than you do to be on the Supreme Court of the United States?
Absolutely, because in the Supreme Court of the United States, Judge Gorsuch doesn't have to answer any question. And he gives you the appearance that he has no opinion, when clearly, if you read the Hobby Lobby decision, he does. And that's perfectly fine. But when you ask questions, it's unacceptable for any of these candidates not to respond to the people who are asking them questions.
You're 100% right, and that's why your process is better. But you also need to look at the questions being asked. We talked about it a couple of weeks ago. Al Franken was asking him about a case and making it look like he was entirely against the little guy and for the corporation, when in reality, we read the case. And all he was saying was, look, the statute is the statute. I'm not going to rule contrary to the statute. Let Congress change it. But Al Franken tried to make him look, you know, the way he wanted to make him look.
But
so
the guy was going to freeze
But
it.
That's
Jim,
right.
Jim, the answer you just gave right now would have been wonderful.
Yeah.
We didn't get that answer.
I completely understand that, but all I'm saying is it's become so politicized that the questions
Absolutely.
are designed in a way so that he really can't answer
And
that in
just
some instances.
In the political arena, we've had recent justices confirm. When I say recent, I'm saying going back to, you know, with Bush and certainly even with Reagan, where they surprised people. As they evolved over the years in the bench, it's becoming less and less likely that's the case, because judges are being vetted by special interest groups as saying this person is acceptable and this person isn't. And that in and of itself, I don't think is good for our system. We'll see how this shakes out, but I can tell you on Friday, one way or the other, I can't tell you the final number, but I can tell you Neil Gorsuch will be the 9th Supreme Court Justice in the United States. All right, coming up next, more legal woes at Fox News. Sexual harassment claims against Bill O'Reilly and others. More cases settled. Advertisers bailing. Now that a pattern of settling is forming, will that make it even tougher for Fox to fight more cases if they come down the pipe?